Alrighty, so the case that we're looking at today is McClure versus Parvis, and this case was decided in the United States District Court of the Eastern District of Pennsylvania in February 6th, 2018, and it's a civil action lawsuit. So we can just, use my highlighter so we know that this is a civil case. So we can look at the plaintiff and defendants real quick. So the plaintiff is Don L. McClure, and then the and Gregory A. McClure, and the defendant is Eric L. Parvis, and the Chester County Hospital, as well as the Chester County Hospital and Health System as well. So here is just a list of the counsel, and in the opinion, we're just going to take a look at that in a second. Let's just see if there's other things that we should look at on this page. So the judge for this is Timothy J. Savage. So here is the memorandum opinion from the judge. So it says, in this medical malpractice action, plaintiff Dawn McClure alleges that she suffered permanent brain injury as a result of the defendant's failure to timely screen and treat her. She names as defendants Pennsylvania Valley Medicine Unionville, which is, I believe, her physician, her primary physician's office, like I stated, which refused to see her when she presented, Chester County Hospital, where she was later taken by ambulance, and Dr. Eric Parvis, the emergency room physician and the trustees of the University of Pennsylvania, who own the Unionville and the hospital. So she's basically suing everybody. CCH moves to dismiss the claim under the Emergency Medical Treatment of Labor Act, EMTALA, which is going to be obviously very important in this case, for failure to screen an emergency medical condition, contending that it performed a timely initial screening. CCH also argues that McClure fails to allege any facts that she was treated differently than any other patient with similar symptoms. McClure claims that CCH failed to perform an appropriate medical screening that would have alerted her to emergency medical condition, a peripheral hemorrhage. She contends that she was examined almost 4 hours after her arrival at CCH emergency department. The emergency room physician characterized her condition as a neurological emergency. CCH argues that a mere delay in treatment does not account to dis parte treatment. So basically, it's sort of like a he said, she said thing, where she's saying that they didn't get to her on time, and they're saying that they did, and they followed the proper protocol under EMTALA. CCH also argues that McClure's presenting symptoms of vision problems and vomiting did not constitute an emergency medical condition that would warrant immediate attention. Because a significant delay in screening may be the functional equivalent of a denial of screening, McClure states that an EMTALA claim against CCH, determining whether there was a delay in screening, requires resolving factual disputes after an evidentiary record has been developed. Thus, we shall deny the motion to dismiss the EMTALA claim. So this is basically the court's opinion on this. The trustees and Unionville moved to dismiss the claims of corporate negligence. They argue they cannot be held liable because corporate liability does not extend to a parent corporation of medical entities or a family practice clinic. In response, McClure counters that dismissal at this stage it's premature whether corporate negligence applies to a particular entity in an individualized inquiry. requiring an examination of the relationship between the entity and the plaintiff. Whether Unionville or the trustees owed McClure a duty of care directly cannot be determined in the absence of factual record. Thus, they have to deny them. They basically denied the motion, and I basically agree with that, because something like this could be seen on like an individual basis. So we're just going to look at the factual background of this case. So on the morning of September 8th, 2015, McClure awoke with a severe headache and vision problems. She scheduled an appointment for later that day with her primary care physician at Unionville. Because she arrived 15 minutes late, Unionville personnel refused to see her and directed her to an urgent care facility. So a fact is that she woke up with her issues, such as the headache and the vision problems. And this is very important too, is that her physician basically denied her any kind of care due to her being late for her appointment. She was sent directly to a nearby CVS urgent care center. She presented to the nurse practitioner there a headache, disorientation, and vomiting. An ambulance was called and arrived around 12:30 p.m. So this is important too, because this basically implies that she was extremely sick. The EMTs transported McClure to CCH emergency department, arriving at approximately 12:50 p.m. Upon her arrival at CCH, the EMT noted she was placed in triage room and was registered. The registration form indicated that McClure presented with vomiting, vision problems. The form stated that she was admitted at 1 o'clock. So this is very important, because if we are talking about the timing of which she got her treatment, you really need to look at like when they admitted her, when they started to treat her, and how that affects the case. McClure was not seen by any medical personnel until 4:42 p.m. when a registered nurse took her vitals, recording her blood pressure at 171 over 88, and that she had a headache and had vomited that morning. Sometime shortly after 4:55, she had a CT scan that revealed a large right peripheral hemorrhage. The attending ER and physician, Dr. Eric Parvis, designated her hemorrhage as a neurological emergency and ordered her transfer by helicopter to the hospital of the University of Pennsylvania, where she remained hospitalized until September 2015. September 14th, 2015. As a result of this hemorrhage, McClure lost vision in her left eye. She now suffers from difficulties with balance and coordination, and participates in both occupational and physical therapy. So now we're going to get into EMTALA. When an individual presents for emergency treatment, EMTALA obligates a hospital to conduct an appropriate medical screening, and if the hospital determines that the patient has an emergency medical condition, it must stabilize the condition. So this is important, because it basically says that it's up to the hospital to determine whether the condition that the patient is in is under a sense of severity that they can treat it. And because this hospital obviously didn't have the proper tools, she was transported to another hospital. EMTALA requires hospitals to medically screen and stabilize all patients with emergency medical conditions in a non-discriminatory manner without regard to financial insured status. And then this case gives a lot of reference to other statutes and cases that pertain to it as well. EMTALA creates private cause of action for one who suffers personal injury as a result of a violation. It does not create a federal cause of action for medical malpractice. So you basically can't use the facts of EMTALA to validate a plaintiff's claim for malpractice. Liability does not rest on negligence or malpractice. Even if the hospital did not deviate from the standard of care, it can be liable if it failed to appropriately screen the patient. Conversely, that a hospital committed malpractice or medical negligence does not mean they violated EMTALA. A failure to screen or delay in screening may be actionable under EMTALA, and inappropriate or faulty screening is not. The latter may be properly brought as a malpractice action, but not as an EMTALA action. So basically, you can't really use EMTALA to validate your case, because that's not really what they're there for if you're talking about malpractice. McClure alleges that she had an emergency medical condition and the hospital did not provide an appropriate medical screening examination to determine whether an emergency condition existed. With respect to EMTALA screening requirement, the statute reads, in the case of a hospital that has a hospital emergency department, if an individual, whether or not eligible for benefits under this subchapter, comes to the emergency department and requests made on the individual's behalf for examination or treatment for a medical condition, the hospital must provide an appropriate medical screening examination within the capability of the hospital's emergency department. According ancillary services routinely available to the emergency department to determine whether or not an emergency medical condition within the meaning of subsection E1 of this section exists. EMTALA does not define an appropriate medical screening examination what it is. It does, however, state that the purpose of the screening is to identify whether an emergency medical condition exists. An emergency medical condition is defined as a medical condition manifesting itself by acute symptoms of sufficient severity, including severe pain. So technically, her headache that caused her to vomit would be considered severe pain, such as the absence of immediate medical attention could reasonably be expected to the result in one, placing the health of an individual in serious jeopardy, and two, serious impairment. And two, serious impairment to bodily functions and serious dysfunction to any bodily organ or part. So basically, she also she suffered some serious damage to her eyes after, but we'll talk about that later. To meet this screening requirements, a hospital must develop a screening procedure to identify emergent conditions and must apply the procedure uniformly to all patients with other symptoms. And this was referred into Byrne versus Cleveland a little bit later, and a few other cases. Thus to state EMTALA's failure to screen claim, the plaintiff must allege that the patient had an emergency medical condition. The hospital did not screen the patient the same way it did the others with similar symptoms. So these are basically the standards for debunking a hospital if they didn't treat you right. Determining whether a hospital meets EMTALA's screening requirements is a fact-specific inquiry. On one hand, faulty screening, such as failure to properly diagnose a medical condition, cannot serve as the basis for the violation of EMTALA's screening requirement. If the hospital is applying its uniform screening procedures, fails to properly diagnose the patient's condition, it may be liable for a malpractice claim, but not for an EMTALA claim. On the other hand, failure to screen is actionable under EMTALA. I'm quoting Carrera at 1192.93, pertinent to the case, and inaccordingly delayed or wholly inadequate screening may be deemed denial of screening. So So that basically means that if a screening of someone who said that they're very sick is extremely delayed, it could be considered denial of screening because the doctor took so long. CCH argues that McClure was screened. It contends that the hospital personnel submitted multiple stat orders for screening. This may be true, but according to the complaint, these tests were not ordered or conducted until several hours after she had arrived to the ER. Whether the testing and examination was timely is a factual determination that is inappropriate for a motion to dismiss. Viewing the allegations in light of the most favorable plaintiff, there was no screening done at the time of McClure's arrival to the emergency room at 1 p.m. until her vitals were taken at 4:42 p.m. She alleges that she had emergency condition, a right peripheral hemorrhage, and the failure to timely treat her condition caused her injury. CCH argues that a mere delay in treatment standing alone fails to state a screening claim. In doing so, CCH mischaracterizes the case law. The cases CCH relies on involved patients who were triaged and examined upon their arrival in the ER. The patients in those cases argued that the hospital failed to conduct an appropriate medical screening examination because the treatment was faulty, not because the hospital failed to conduct any screening whatsoever or did so too late. The question is not whether there was a screening. The critical question is whether the delay in screening amounts to the outright denial of screening sufficient to state that an EMTALA claim. Answering this question requires making factual determinations that are not resolvable on motion to dismiss. So I believe that this paragraph is important because it's not necessarily talking about if she got care, because she doesn't deny that she did not get care. But the problem is that the timing of the care was she believes that it's one of the causes to why she got so sick and she lost vision in her eye. A delayed or inadequate screening may in some circumstances violate EMTALA when the screening is so delayed or inadequate that it amounts to no screening. The hospital may be liable for failure to provide an appropriate medical screening examination. Thus, an EMTALA screening claims a motion to dismiss is an allegation of lengthy emergency room delay in screening resulting in failure to identify, treat, and stabilize an emergent condition. In the complaint, McClure argues specifically that the defendants failed to perform an appropriate medical screening, which is A, timely upon arrival, consistent, and presentations of patients with substantially similar complaints, consistent with the presentation of patients who arrive by ambulance to the Chester County Hospital Emergency Department, and treating Don L. McClure disparately from other similarly situated patients. These allegations are sufficient to state a claim. McClure alleges that the CCH is incoordinate delay in screening has inconsistent with the way it treated similarly situated patients. Whether McClure's presenting symptoms of vomiting and vision problems alerted to an emergency medical condition with CCH argues they did not one of the fact and cannot be determined at an early stage. So basically all of this means that she felt like she didn't get the proper treatment that she deserved due to her condition, but they're arguing that they can't really determine that her condition is that severe in such early stages. Symptoms like vomiting and vision problems in isolation may not constitute an emergency medical condition. However, they might herald the onset of an emergency medical condition when coupled with additional information like medical history that would inform the physician's interpretation of that symptom. So if she had like pre-existing conditions like diabetes or like a history of migraines or something like that, then maybe the doctor might have taken it more seriously. That's what I'm getting from this. And I believe these are all just footnotes. However, sort of emergency condition and coupled, blah, blah. Yeah, so basically all of these just confirm what I just said. And then here are just some other footnotes, basically reiterating what was just said. CCH contends that McClure was not alleged disparte treatment. With respect to the argument, McClure may show that the hospital followed the screening procedures, but the procedures were not reasonably calculated to identify critical medical needs. Merely because the hospital uniformly applies its screening procedures does not necessarily make it appropriate or adequate. So that's basically confirming what you said, saying that it doesn't even matter if you have the screenings done. If they're not done in a accurate time, then that's where the concern lies. The screening does not satisfy the EMTALA obligation if it is so cursory that not designed to identify acute and severe symptoms that alert the physician of the need for immediate medical attention to prevent serious bodily injury. Alternatively, she may prove that she was not screened consistent with the standard screening procedures, giving rise in the conclusion that she was not treated in similarly situated patients in either event. She may recover over EMTALA. Viewing the allegations of the complaint in light of the most favorable to McClure, as we must in this stage, she was alleged enough to give rise in inference that she received no meaningful screening while her emergency condition deteriorated under the time she was unexamined for almost 4 hours, resulting in physical harm. Therefore, we shall deny CCH's motion to dismiss. So basically, the judge ruled in favor of McClure because he determined that 4 hours was a significant amount of time that they left her alone enough for her condition of her headache to deteriorate. And so now they're going to talk about corporate negligence, which I don't feel like is too relevant in this case, but it is something that could be looked at as well in regards to the role of the hospital and how she ended up. Under Pennsylvania's law, a hospital has a non-delegable duty to adhere to the proper standard of care to ensure the patient's safety and well-being. The hospital's duty is independent of any third party. In other words, corporate negligence does not depend on establishing a third-party negligence. Thus, a hospital may be liable if it deviates from the standard of care. So basically, it's the hospital's problem if their patient is not getting the proper care. The non-delegable duties fall into 4 categories. They are: 1, a duty to use responsible care and maintenance of safe and adequate facilities and equipment. 2, a duty to select and retain other competent physicians. 3, a duty to oversee all persons who practice medicine within the organization as patient care. And 4, a duty to formulate, adopt, and enforce adequate rules and policies to ensure quality care to patients. So those are basically the standards for customer care. Well, not customer care, but patient care. To state a claim for corporate negligence, the plaintiff must allege that the medical entity breached one of the non-delegable duties, and the medical entity had actual or constructive knowledge of the defect or procedures which created the harm, and the breach caused patient substantial harm. Liability for corporate negligence is not based on respondent superior. It arises from medical entities' own acts and omissions. The focus is not on what the employee did or did not do, but rather on the employer, but rather on what the employer did or did not do. That's a very odd statement. I don't know. I don't like that sentence. A claim for corporate negligence arises from the policies, actions, or inaction of the institution itself rather than a specific act of individual hospital employees. And then they just cite some more cases. Unlike various liability, corporate liability requires that the defendant had notice of the conduct of the issue by virtue of its own misreference or non-reference, the hospital knew or could have known about the breach of duty is harming the patients. So basically, if the hospital knew that this person wasn't getting sufficient care, they could be held liable. The corporate negligence doctrine has been applied to certain non-hospital entities. A health maintenance organization, HMO, may be held liable under a corporate liability theory. Most recently, the Pennsylvania Supreme Court had a nursing home and the management company overseeing patient nursing home liable under corporate negligence theory. Corporate liability had not been extended to a physician's office because the office does not perform the role of comprehensive health center with responsibility for arranging and coordinating the total health of its patients. In determining whether a non-hospital entity shows a plaintiff a duty, courts applying Thompson had focused primarily on the role of the entity plays in arranging the coordinating the total health care in the patient's comprehensive health center. So for this one, it's basically speaking on like the standards that they have for corporate negligence and stuff. The shift in focus does not render an examination of the relationship between the corporate defendant and its employees who care for patients meaningless or unnecessary. On the contrary, to discern whether the corporate defendant owes the plaintiff patient a non-delegable duty, one must examine the extent of the corporate defendant's oversight and control of the medical professional directly. To determine whether a relationship between a defendant's corporation and patient gives the rise to the duty of care, we apply Section 323, which is one of the rules of the restatement, Sackmore the Third, 169. So that's basically another case. So basically, one of the intakes. One who undertakes gradually or considers to render services to another which would recognize as necessary for protection of other persons or things is subject to liability in the to the others for physician harm resulting in his and her failure to exercise, if A, his failure to exercise such as increases the risk of harm, or the harm is suffered because the other reliance upon an undertaking. So that's an important rule to look at as well. Restatement, second of torts. Thus, this section applies where the defendant agreed to oversee and provide proper medical care. Union agrees proper liability. Physical groups. It is true that the Pennsylvania Superior Court declined to find the physician's corporate practice liable to corporate negligence. Okay. Focus on. Now I'm just trying to look at what pertains to this case because I feel like this is definitely a lot more fluff. McClure averse facts, if proven, would demonstrate that Unionville owed a non-delegable duty to her to ensure that their safety and well-being. She alleges that Unionville was responsible for caring her. She claims that she made an appointment with her primary care physician at Unionville after waking up with a severe headache with vision problems because she was 15 minutes late. So that's basically reiterating what we talked about before. Most three allegations surface claim of Unionville at the stage. She claims that in turning her away, Unionville breached the duty to exercise reasonable care, increasing her risk of suffering physical injury. She also alleges that as a parent corporation overseeing the care of Unionville at the CHH emergency room, the trustees are liable to corporate negligence. The trustees counter that is not a hospital and merely operates as a parent corporation of for various health care entities. and they're basically not a brick and mortar facility, so it's not necessary. So they're basically stating that it's not necessarily their problem. The Unionville and or CCH required that it would be notified if incidents, if problems with patient care, or establish the rules and regulations about how each facility operates. Unionville and trustees argue that the two corporations cannot both be held liable for corporate negligence because the duties are non-delegable. They contend that allowing the claim to go forward against multiple corporations, finding the way they both owned McClure in a duty of care directly will result in multiple entities being exposed to liability breaching the same duty. They argued that one defendant may be liable for corporate negligence and if any party had a direct duty to McClure was CCH, not them. Unionville and the trustees request we find, even though there's no evidentiary record that they owed no duty to McClure. In response, McClure concedes that the only one defendant that can be liable, she claims that Unionville was negligent for turning her away and she was late for her appointment. She alleges that CCH was negligent for delaying her emergency room screening for almost 4 hours. As for the trustees, she claims its corporate negligence stems from the events that transpired either at Unionville or CCH. This type of individualized inquiry into the duties ensures multiple entities are not exposed to liability for breach in the same non-delegable duties. So now we can just go to the order. So basically, on this day, February 2018, upon consideration of the trustees of the University of Pennsylvania and Penn Family Medicine, Unionville partial motion to dismiss for failure to state a claim, and the plaintiff's force, it is as ordered, and that motion is denied. So they basically denied their motion. And upon consideration, the Chester County Hospital and the Chester County Hospital and Health System motion for partial dismissal for failure to state a claim, and plaintiff's response is denied. So basically, the judge denied the motion to dismiss their claim because even though they argued that they didn't really have a liability towards her, she proved that with them waiting 4 hours to screen her in something that could have taken a lot less time because she was having a headache and she did come there by ambulance, that she was basically correct in suing them.